Oh, I'm
Basil,
going to
can you
introduce
adjust?
our
Basil,
speaker
can you
is
adjust your
Basil.
camera so we can see you better? We only see the top of your head.
Who's this, me?
Yeah,
Oh, yeah.
yeah.
Okay, before we go further, I'm going to introduce our speaker, Basil Plastiras, who is a past president of the Hellenic Law Society. By his own count, he's been doing legal malpractice for 52 years, which I think is a little inaccurate, Basil, because
It
I went
is.
to law school a year after you, and I've been
Right.
practicing 48.
That was
Yeah.
Venetatos. I misspoke. I apologize.
But Basil has been doing legal malpractice work, many cases. I have consulted him on a time. I think I designated him as an expert. I think he used me as an expert in a franchise case.
Hmm.
So we're really lucky to have him. The topic is avoiding legal malpractice.
Can everybody see that? Nope. It's
No.
not very clear.
Now,
Don't know what's
No,
going on.
Remove
Well, this is a book
turn off your
by
background
an
blur.
attorney named Hilton Stein, and the title of the book is "How to Sue Your Lawyer." And this is just one of several that are out there. Uh, Lawyers, we can be targets. I'm not saying that every lawsuit against a lawyer is bogus. To the contrary, there are some very legitimate ones. But it's unusual. When I started practicing in the
A
70s,
video came.
oh, okay. So when I started practicing in the 70s, I was working for a mid-sized firm, and a legal malpractice case came in, and nobody had ever handled a legal malpractice case because they were so very rare in those days. Uh, that's changed. But at the time, they asked everyone at the firm, has anybody ever handled one of these before? And everybody said no. So they gave it to me because they said, well, I won't screw it up any more than the rest of them. So that was my entry. Uh, the attorney uh, was named James Baccardo, who,
Oh, biggie.
yeah, the Baccardo law firm is still down there in San Jose. And in fact, my brother-in-law is a partner there. But James Picardo was a very big lawyer back then. And he was doing a lot of mass tort cases, airplane crashes, and the like. Very, very successful. But in this case, he had neglected to collect all the damages that my client was entitled to. So I called him up. We discussed it. He said, send me a letter, a demand letter. I said, okay. I wrote up a demand letter. And a couple of days later, I called him and he picks up the phone and he says, I'll send you a check. And he hung up. And that was my entry into legal malpractice. It was extremely rare in those days, and it's only gotten more popular every year since. The good news is that there's really a lot of defenses, which I will talk about later on. But there are some that are only applicable in a legal malpractice case. The litigation privilege is one. The judgment
Basil,
call privilege.
the camera is tilted again.
Okay. How's
That's
that?
better. That's better.
Okay. So, uh, yeah, the other one was litigation privilege and the judgment call privilege. And the reason for the judgment call, well, the litigation privilege is to protect the all witnesses, lawyers, and parties from being sued for their testimony. And it's been expanded now to their letters and so forth. And if it's in the course of litigation, it is protected. And that's a matter of public policy because they don't want anybody to be afraid to testify if they're going to get sued. The other one, the judgment call privilege, in litigation, there are so many possibilities that so many defenses that attorneys are afforded the judgment call privilege so that, for instance, you got a case where there's questionable liability but pretty severe damages, and the plaintiff attorney wants to go forward with it. And that's his recommendation to his client. And in this particular case, because the damages were very serious, if he took it to trial and lost, the first defense asserted would be the judgment call privilege, because nobody knows what the outcome is for any trial, any dispute, whether it's the court or a jury. And that's a defense that is frequently used when things go wrong at trial. Let me get my... there are just so many potential defenses. And I will get to those later on, but here's a list of which clients not to accept. First of all, any client that is not completely honest with you, because if they're lying once, they're going to lie again. And if they lose, they'll very likely blame the loss on you. Any client that is crazy, and I mean that literally. Over the years, I've had some completely crazy clients and some completely crazy plaintiffs that on the other side. I had one woman who came into my office all dressed in purple velour with white lace, and she seriously told me that she was the true owner of the crown jewels of England. There's not much you could do for her. You just smile and let her go.
Well, ask her for a retainer of one jewel.
Well, what she wanted was for me to secure the jewels for her. And I mean, she was honestly mentally ill. And there are, I have to say, unfortunately, quite a few mentally ill cases. I've had both sides of that. My client turned out to be mentally ill, and the other side was mentally ill. I had a case where some family lawyers were being sued because their client, this rather striking woman, had lost parental rights, not just custody, but all parental rights over her kids. And the reason was that she was psychotic, and she had done some things, and it finally got to the point where the city filed a petition for to remove all parental rights and put the kids up for adoption. It's sad that that has to happen at times, but that's not that unusual. I'll explain. This woman was arrested. The turning point for her, and in the eyes of the city, the turning point was when she walked through the lobby of the St. Francis Hotel completely naked and in a psychotic episode. Uh, and I couldn't figure out. I mean, it was a terrible thing to lose. You lose your children; they're taken away, and you'll probably never see them again. But uh, but she was genuinely ill, and she had had repeated events like that. So, in the interests of the children, they took them away. And I couldn't figure out why this attorney was prosecuting it. And he came in one day to talk about the case and about settlement. And as he's sitting there, he started to cry. And I thought, oh my God, what's going on? Well, apparently he had lost custody of his children for somewhat similar reasons. So it's always good to know the motivation of the opposing attorney. Uh, let's see. Uh, any client that changes.
I have a question about the
Sure.
client that's less than honest to you. That is never, in my experience, is never presented when they want you to represent them.
Right.
They put on their best face.
They do.
It's down the road, and it may be subtle what they're doing, and you've spent a lot of time, and you're in. Can you comment about that type? I mean, I think we've all had cases like that where suddenly we realize the client isn't exactly what we thought they were.
Yeah. Oh, that does happen. And there are times that they fool you. But when you find out that they have been misrepresenting facts or fabricating them, uh, that's the time to get out. Uh, it's not a good idea to stay in a case. You're on the eve of trial. The client you know is lying to you, and you're hoping, without a lot of hope, that uh, there can be a recovery there. It isn't worth the risk. The risk increases the longer you remain in the case. In fact, it waters down the defense of not believing an incredible client. So it's better to get out as soon as you know. And they could go to some other attorney that maybe could help them or maybe get in trouble. But in any case, you don't want the trouble. Also, any client that is unduly focused on money. Now, that is a bit scary because their interest is not necessarily in making themselves whole. It is in getting the money that they think they need. Uh, and I'm defending. I'm testifying as an expert in a malpractice case tomorrow, where the attorney represented a plaintiff who had a problem with young women. He was a teacher in Santa Clara County, and he had been fired. The attorney took the case, and he actually got a terrific settlement the day before trial. It was $1.5 million, I think. The client has now hired new attorneys and is suing my client, or not my client, but the attorney that hired me, because he thinks the attorney's getting too much. So again, you got to watch out for people whose primary interest is how much can I get? Anybody who quibbles about fees is a higher risk than average.
Did the Basil? Sorry for my camera's not working, Jim Fatinas. But did he have an engagement letter with the client that's complaining about the fee?
Oh, yeah, there's an engagement letter. What's complicated is that they changed the fee arrangement 3 times during the course of the litigation. Started
Oh,
out on a straight hourly, the guy couldn't pay that. So they went to a hybrid and ultimately to a percentage. And they
oh,
settled it on the day before trial was to start. And they got a
uh,
million eight, I think. But this guy thinks he's entitled to more than the 60% he's going to get.
shit.
Yeah.
Usually fee disputes, what, at the option of the client, can go to our arbitration, right?
At the
Uh,
option of the client. And one
and
of
he,
the nice things about that is they can go to non-binding arbitration,
right.
advisory arbitration. There's a lot of ways you can do it. And looking at this particular case, if they had gone to at least non-binding arbitration, they would have a decision now. But
So,
it
so,
might not have been binding with this guy. He wants the money.
so he didn't elect to do that.
No, he did not. But it is something that if it ever happens, I would encourage you to do so. I've been a state bar fee arbitrator for 25 years, and uh, we see some pretty wackadoo cases and it's almost always the client and not the attorney. And then we can, well, usually it's a three arbitrator panel,
Wow.
and we can, talk to them individually and informally and see if something could be worked out that everybody can live with. Or if
Basil,
we have to, we reach a formal decision, which is binding upon the parties.
Basil, I have a question. Our good friend Ted Kleinis, past president of Law Society, was defending a case, and he used to talk to us when his office was down the hall from ours. And he said something to the effect that a lawyer cannot change the fee arrangement without sending the client to another lawyer to ratify it and bless it. And it's
Yes, you're
yeah,
talking about the Ramirez versus Studevant case, which arose out of San Francisco. Jim Studevant is still around. He's here practicing in Marin now. Uh, Basically, that is correct. Uh, in
Well, it has to be informed consent.
has to be informed consent in writing.
Yeah.
Okay.
So that would
Anytime,
nail that. Yeah.
yeah, anytime anybody any client wants to change the terms of a fee agreement, you had best advise them uh, to go to another attorney for at least advice. In this particular case, I mean, they got $1.8 million settlement, and the plaintiff wants more, and I don't think he's going to get it. And
No
the
shit.
reason in this case is that the attorney and client had 3 different fee arrangements, one after the other, all at the request of the client. And after the second fee agreement was made, the client decided that he wanted to go look for another attorney, and he did, in fact, do so. And he went to 12 different attorneys, and not one of them would take it. So he went back to his original attorney, who continued to work up the case, and they settled for like $1.8 million from the Santa Clara Unified School District. And I thought that was remarkable for a guy who had multiple complaints by. Uh, he was teaching at the junior college level, so they were young, but they weren't children. But nevertheless, there were multiple complaints, and I was amazed they got that much money. out of a school district under those circumstances.
Who's representing the attorney?
I am. No, I'm not. I'm sorry.
You're
I'm
the
the
expert.
expert for the
Right.
attorney. Oh, yeah, a really good attorney by the name of Chip Cox out of the East Bay, I think San Ramon. And he called, I do a lot of work for Murphy Pearson, and he called up Murphy Pearson and needed an expert, and they referred him to me.
Okay, yeah,
Uh,
because he's going to win.
oh, I think so. Yeah, I really
Yeah,
do. Uh,
yeah.
anyway, and I'll tell you, I had I've tried maybe 25 legal mal cases to verdict, and we only paid money in two of them. And in those two, uh, one of them, our 998, was higher than the verdict, so they didn't get any costs. And in the other case, they wanted close to $1 million, and they got 200,000, primarily because my client, this is a mistake I'll never make again. My client, he was a nice guy, but not a great attorney. He was owed money from the plaintiff in the malpractice case, and I couldn't represent him due to the conflict. He represented himself, and he did a horrible job. He essentially made the plaintiff's case by being inarticulate in front of a jury. Uh, so that's one thing you always have to worry about. What's your client going to look like? Okay, let's see. Any clients that are highly emotional, that are angry and want to get the other side, are good to avoid. Or if they need money, like in this current case, the guy wants he wants a lot more of the money than he's entitled to contractually. By the way, the case that I mentioned about fees, it's a 1994 case out of the Court of Appeals, and it is the seminal case for at least a dozen decisions regarding disputes over attorney's fees. And basically, in this case, well, let me get the rule down first. Every time you change a fee agreement, you have to advise the client of their right to consult other counsel. And in this particular case, that did not happen. But I don't think it's going to make a difference because the point of the Ramirez case it was the twofold analysis. Rule number one is, did the attorney follow the rule to advise of their right to independent counsel? And rule number two is, let's assume that they didn't. Was the fee excessive or beyond a reasonable fee agreement? And there we've got it nailed because he went out and consulted with 12 attorneys who wouldn't take the case. The law firm did modify the fee agreement twice, but they did not advise him in writing of his right to go see independent counsel. But I don't think that's going to make a damn bit of difference. It's the same exact situation in the Ramirez case, where the attorney did not advise the client to seek new counsel, but the court at the trial and appellate level felt that the fees were reasonable. And in the case that I'm testifying in, they took a 40% fee, which on a case that goes to trial with someone who has sexual abuse claims against them as a teacher, I think that the 40% was very fair, a little below what it might have been otherwise. So I don't think we're going to win on the technical ground that they did advise him. But he, like I say, before the final agreement, he saw 12 attorneys. Nobody would take the case. Okay. Also,
Basil, if the lawyer wins, can he collect attorney's fees under the engagement letter, prevailing party, or not?
I don't think so.
Yeah, usually they don't include
I
that. Yeah.
can't remember the letter. I got to look at that. But I do not recall any fee agreement, any agreement to fees to the prevailing party.
Too bad. Could be
Yeah.
a big number. You'd get the client would get the other 60%.
He might. He might. I haven't met or talked to the defendant attorney.
Oh,
I just know Chip, and he knows what he's doing, and he spotted this too. So I'm pretty sure that was it was a two-stage appraisal. One, did they follow the rules requiring advice of counsel? And if they didn't, rule number two was it a fair fee? And if it was, rule number one is irrelevant. But that's a rule you want to remember. Okay, let's see. Every once in a while, you may come across, if you're unlucky, uh, a client who has sued attorneys in the past. And I think that often they're motivated by money, but in other circumstances, they have a grudge against some attorney, and they're still working it out emotionally. So that's someone to avoid. Now, the the beautiful thing about legal malpractice is there are so many possible defenses. And a lot of times, you'll lose on the case in chief and then win on the affirmative defense. But one of the greatest affirmative defenses, I use it all the time, uh, is the litigation privilege. Now that's Code of Civil Procedure. No, it's a Civil Code 47C. And basically, it is designed uh, to protect the sanctity of testimony. But it's not just testimony. Over the years, it's been expanded. Oh God, I represented Quentin Kopp in a really unusual case where uh, he and his partner were being sued. They handled a divorce of a very wealthy Pacific Heights. What was he? Oh God, but he was wealthy. And after many years of marriage, his wife finally got pregnant. And the husband was very excited, remodeled well, when the baby came out, not only was he not 100% Caucasian, but he had severe disabilities. And the divorce and the rule of law is if you're married and living with your wife at the time she is made pregnant, then you are responsible for the expenses of the child for the rest of its life, even if it's not biologically, even if it's not provably not your child. And this case was interesting because the man who impregnated the wife was Eldridge Cleaver. And I had met him actually once at Berkeley years when I was a student there. And we actually got along great. He was very cooperative with our case. He was broke. He had lost all his money on those cod pants that he was trying to market, and he had nothing to pay. So uh, the whole idea is behind the law is that the state government does not want to have to support all of these kids. And in those days, fathers could simply say, or husbands could simply say, doesn't look like me, it's not mine. But they wanted this rule to alleviate that kind of problem. Uh, in any event, I made a motion for summary judgment based upon the statute, and the trial judge denied it, but we took it up to the Court of Appeals, and they reversed and uh, dismissed the case. Okay.
The statute of limitations?
Statute of limitations is a very complex defense. It's got several criteria. It can be anywhere from 1 to 4 years or longer. The classic case, I had a case like this. Suppose an attorney draws up a will and it's defective, but nobody knows until the testator dies. And then it's looked at and it's found to be inadequate. And that's pretty much what happened in the case I had. So the 4 years can go much longer. If someone's alive, the same will or trust is viable, but defective and found defective when they die. So the statute of limitations can be a very long one. This was 25 years. And we lucked out because we found another carrier to take over the claim, so that his current carrier wouldn't penalize him.
I thought the statute on malpractice is 1 year. I mean, there's always a question
That's the shortest possible.
Okay.
But if the damage has not yet occurred, it can be indefinite.
Okay, even if you disengage, that's the hook. Most people blow it. They don't formally disengage from the client, and
Even if you even if you do disengage, if you've drafted a document that many years later turns out to be defective,
mhm.
you're on the hook.
Hmm.
Unless you could prove,
They should have known. Yeah.
right, and that's a hard one because you got lawyers dealing with lay people, and the courts do not expect much of lay people. So that's one thing to consider.
So the damage accrues when the person dies and the will is now going to be effective.
Right. Yeah.
Because any time up to that, they could rewrite the will or do something else.
Right, exactly. Yeah. But if they keep the same will or trust and it's defective, then there's a problem. Uh, just a brief word about malpractice insurance. Almost all policies these days are what's called claims made, as opposed to claims accrued. And this particular insurance policy that was 25 years old, it was a claims accrued policy, which is one more reason that carrier had to cover it. The policy accrued, I'm sorry, the negligence occurred during the viability of the original insurance policy. If the lawyer makes a mistake 10 years ago, and there's a claims accrued policy. Now, most of them nowadays are claims made. which is both beneficial but can, in some circumstances, not be. But if you're switching carriers, you probably want to ask about prior acts coverage. Uh, because if your prior policy was a claims made policy, then you could have a problem with coverage. So that's always a good idea. You know, get more coverage than you need because almost all of these policies deduct the cost of defense from the covered amount. And some of these cases can be very expensive.
Plus, on a claims made, you should buy a tail policy when
When you retire,
yeah,
absolutely.
you know,
Yes.
so in effect, it's an extended notice
Yeah.
rider, and it's usually 6 years, peace of
Well,
mind, and the premium is,
you could
depends
go
on
as long as 10, I've seen, but you
okay,
have to pay more.
yeah. Well, at least in the D&O area, the premium for 6-year tail is like 150% to 200% of 1 year's premium. Do you know what they are in attorney coverages?
Oh, yeah, I could tell you. Let me think a second.
'Cause,
I
that's
think they're 100%, but for how
so.
long is the
So if
question?
you're paying 25,000 for a 6-year tail, they charge 25,000.
Uh,
That's a deal.
it could be. You know, it depends upon the amount of coverage, of course. Uh, I have seen attorneys when they retire get a more modest uh, uh, tail because they really only care about the defense.
Yeah. Well, if you're an estate planner, if you're right, you should get a 50-year tail.
Yeah, right. Theoretically, it could be. The people live so long now. Okay. You
Well,
know, you should.
that's an interesting question. So, in say a will, can the attorney has passed away? Can they sue the estate for the malpractice, or does that like slander go away when you die?
Well, it depends now. Uh, if the estate has been distributed, then I think it's very unlikely, but the policy may still apply.
Hmm,
So,
okay.
okay. Uh, I would recommend you do not accept as a client anyone who has sued an attorney before. Uh, there's a lot of people out there who resent attorneys, and maybe they got sued by someone and blamed it all on the attorney. But I think that it's advisable to ask the client, have you ever hired an attorney before? What case was that, and how did it turn out? Uh, it gives you a perspective on their attitude towards lawyers. Uh, other, let's see, we're talking about defenses again. There are probably a dozen defenses to, let's see here. A dozen or so defenses to a legal malpractice claim. And we've talked about a couple of them. I don't think we need to go into detail on the statute of limitations, even though it's very complex. If your policy is active at the time, then you're very likely going to be covered. I don't know of any claims accrued policies still being issued. And of course, the reason for that is the carriers realized that they were money losers. Okay. Uh,
They've gone the way of the dodo bird totally in the legal profession. But
As far as I know. And
yes, someone
that's,
once said to me, doctors still get occurrence policies. That it's not uncommon in the medical field
yeah, you mean occurrence uh,
for
tail.
negligence, whatever
Yeah,
doctors is
yeah,
for every day.
yeah, yeah. Uh, let's see. I did make some notes here on avoiding conflicts of interest. This is a common area, and it is especially common when there is a large law firm involved. And the reason for that is that the clients that a large law firm has are numerous, and there could be an issue with a conflict of interest. Uh, Now, the larger firms, in conjunction with the cooperation of the court, have created what they call a China wall. The idea is if they're handling a case where there's a potential conflict of interest, uh, if the firm takes measures to isolate the lawyers uh, involved in that case from the lawyers that are representing the client currently. Uh, I don't know. It's a tricky situation. Uh, I don't necessarily trust the China wall.
Yeah, it's tricky. The
Well,
huge
it's easy
area
to get
for
around.
the huge problem for transaction lawyers is conflicts because if an insurance company sees a claimant asserting conflicts, they effectively say to you, "We'll have to settle this case." The and the issue, like you form, and it comes up all the time with small companies. So you form, five partners come to you. They want to form a company, create a better widget, and you do the incorporation papers. So you do a shareholders agreement, blah blah blah, maybe an employment agreements. And it's really critical that you make clear at the outset that your client is the corporation, not the
Exactly.
individual shareholders,
That's
and
it.
that each individual shareholder, if he or she wants to protect his or her own interests, should hire a separate counsel, and that should be in the engagement letter. And it should be signed by everyone because you form the company and there's a dispute, and they say, "Well, Jesus, I didn't, why didn't you tell me about these
Yeah.
issues?" So it's brutal. And then
Yeah.
the other trick that people stumble on is even if you get a waiver up front, say, "Yeah, we acknowledge you're representing the company, not any of us." If a dispute actually arises down the road, a real live dispute, now uh, you have to consider getting a separate waiver of conflicts. That is really tricky. So it's just not you get it up front, but if an actual dispute, they start getting into a fight, then you've got, you, you could get disqualified from representing anyone if you don't
Oh, yeah.
get a second waiver.
There's a principle of conflicts of interest called the hot potato rule. And what some firms have done in the past is they get a big new client in, and they're going to have a ton of work from that client. It's just, however, a problem that there is a current client who is not that profitable for the law firm. And so they drop the current client for uh, the new client, and that's a violation of the hot potato rule.
That's a big, the Supreme Court, the Shepard Mullen, a Supreme Court
Yeah,
decision like 5, 10 years ago. That exact case, they were representing, I think, the South Lake Tahoe Water District, small
yeah,
client, and the developer, someone, some mega hired them, and they just dumped the water district, and it
yeah,
went all the way to the Supreme Court. And I think the Supreme Court said, "No, your advance waiver in your engagement letter with what doesn't work, you blew it." And I'm surprised they didn't settle that case because that Supreme Court decision, Shepard Mullen, just really
Yeah. Oh, and
hammered it.
that's not the only one with Shepard Mullen.
Yeah,
They've got two or three
yeah.
uh,
So
significant cases. I don't know. Well, anyway, it doesn't matter. Okay. Uh, so we've talked about avoiding conflicts of interest. Remember, please do not overpromise. Be modest in your predictions for the outcome. Better to have it's better to have a client who knew he could lose and came out slightly disappointed than a client who was sure he was going to win, as so many clients are. I mean, even attorneys, they're sure they're going to win. Not all the time. They're better than the lay people out there. But okay, again, on conflicts of interest, don't ever take a personal stake in the outcome uh, as part of the deal. Now, that doesn't mean you can't take your percentage, um, but if it's involving a business or anything else, and uh, they offer you uh, something other, be very careful about that. Uh, Also, be mindful. I mean, you have to have a certain amount of skepticism with clients. I've had some lawyer clients. You'd think they're going to be straight and above board, and that's usually true, but not always. So if you discover something that is adverse or that creates a conflict, you cannot sit on it. You notify them as soon as you can and advise them to consider consulting with other counsel on it.
there's a ABA letter, like Wilson Sonsini in the old days, maybe still. They set up a fund for the partners, and they would invest in their startups or take stock in kind or something. And they actually got a ABA ethics letter that set out the rules for taking an interest in a client. So that one should look at that if you're tempted to
Yeah,
take a piece of the next Google or something.
yeah. Let's see. Okay, don't overpromise and put it in writing. I mean, email is a wonderful way to communicate. It's fast, it's immediate, it's easy. Uh, and it's important to advise the client of any adverse facts that have come up or adverse issues of any kind, because you want to keep them focused realistically on the potential outcome. Let's see. Obviously, put it in writing. Uh, Also, it's a good idea to establish a protocol for client communications so that the client hears from you on a regular basis and is aware of all events in the case that are significant so that they're not surprised and possibly angry if there's some negative information that came out a while ago. Anything that affects the value of the case should be conveyed promptly and quickly. Years ago, I had a case where I was defending an attorney who represented a landlady in Chinatown. And I believe she was referred to as the Witch of Chinatown. Uh, and this was really before email was all that popular. The judge took a look at my client's file, and she had everything beautifully written out in perfect handwriting. And the judge was so impressed, she threw the case out. Uh, you never know what's going to trigger something like that, but cross your fingers and do all you can. Okay, I'll just run over the things to prevent claims again. I'm sorry, I don't mean to be repetitive, but some of these are worth repeating. Number one, provide excellent service. Do not practice outside your field unless you bring in an attorney who is experienced in that field. This law is so complex these days. Clearly communicate. Keep open the lines of communication and make sure that the client understands the limits on the scope of your service. And advise them more than once about the potential risk of, for instance, losing a trial. Meticulous documentation, we talked about engagement letters. The state bar has all these web pages that assist us on employment contracts, on letters of advice. In addition to that, there's a whole body of law that they have in arbitrations and the rules that they've set up. So it's on the bar webpage. It starts there. You could go deeper. There's something called the compendium of decisions, I think it is. So don't hesitate to use their fee agreements. And this one is avoid dabbling in too many areas of practice. Confine yourself to 2 or 3. Beyond that, you're running risks. Everybody it seems, is specializing these days. According to the American Bar Association, attorneys in private practice have a 4 to 17% chance of being sued for malpractice every year. So that's pretty significant. And it's not worth taking long shot or unfamiliar type cases because a claim can really hurt you. And some of the carriers are better than others, but some of the carriers will cancel the policy or refuse to renew. And then you're stuck without insurance, and you got to jump around to find some policy, some carrier that will insure you. And that policy may be a crappy policy from South Dakota. We talked about clearly defining the scope of representation. I think we've done that. And avoiding problem clients. Use your gut. If you don't like the client, if there's something about them makes you suspicious, don't take it. Don't even refer them out. Although I suppose you could refer them out and advise the attorney you're referring them to that there's something weird about them. It might be worth it to do that. Let's see. Proceed with caution when outside your usual areas of practice. And it's a good idea to bring in, associate in an attorney in that particular field if that's not your expertise. And that's commonly done, and it really it makes for a great defense if anything goes wrong there. That you have another attorney who's the specialist and you're just the generalist. And courts and juries tend to, there's a higher standard of care for anybody specializing in anything.
Yeah, well, that's a lead in. So you look at the Hellenic Law Society membership for a referral.
Yeah, there you go.
Peter's
Any questions?
book. It's very
No
good, Basil.
questions. Any comments?
And here the comment, well, you can't retire, Basil.
Yeah, well, I haven't yet. Although the only thing I'm doing now is I'm doing expert witness work.
Yeah, well, that's
Uh,
nice.
no
Less wear and
more
tear.
personal litigation, and it's almost liability free.
Well, raise it. I do expert witnessing, and I have now put my engagement letters on the an indemnity from the client for any third party claims, because you have some of these speak of wild litigants. They'll not only sue everyone, they'll sue the experts. Now that
Oh
yeah,
yeah,
litigation
yeah.
privilege, and
Oh, experts have been sued before.
you know.
I've managed to avoid that.
So, but I mean, it's worth considering putting in your engagement letter, since this isn't subject to the rules on. You can't in your engagement letter hired as an attorney, you can't put a indemnity. Uh, uh, the client can't indemnify you, I think, at all. Certainly for malpractice. But on a expert witness, you could say, hey,
If
yeah, I'll
it's
be
a
your
third
expert
party
witness,
claim,
but if the jerk, sues me, I want my defense costs taken care of.
their homeowners insurance might cover them. I got sued just recently by this wackadoo former tenant, uh, uh, and he's got two convictions for fabricating documents. And what he did was he filed for bankruptcy after I sued him, but I did not get notice. And so I continued suing him and I got a judgment and put a lien on his property. So he's suing me now, and I'm covered by the we have on that property. And it's great to have uh, it's great to have a lot of insurance. And I think different kinds of insurance. Some of it is comparatively cheap, like property insurance by comparison to legal malpractice insurance. It's a good way to go. And if you, in this case, I was representing the property, so the carrier for the property did accept the coverage, and they're working it out now. Anyway, any other questions or comments?
What you said you tried 25 of these, Basil. Did you have another 100 you represented that settled these malpractice cases, or
Oh,
is
no,
there
no,
is
I
there
tell you, I have no, that's the expert witness work that I
oh,
do.
it's expert witness work?
But I guess I did say that I tried about 25 legal malpractice claims. Yes, that is right. Um, yeah, the thing is that in most of the cases I got out, I got my client out for one of these defenses, summary judgment. I think I had 17 or 18 summary judgments in a row. And uh, it wasn't that I'm such a brilliant lawyer. It's that in those days, there were very few sophisticated legal malpractice lawyers. A lot of them didn't have a clue. They were PI attorneys who decided they wanted to expand their practice. And they just walked right into the affirmative defenses. So you want an attorney who's very sophisticated if you ever do get sued. You want somebody who's going to know all those defenses and hope that the plaintiff attorneys don't. I think they're a little bit better these days than they used to be, but there were just complete novices 30 years ago.
Well,
Uh,
my question was more about the carriers. When an attorney is being sued, they bring in their malpractice insurance. What is the propensity for these carriers to settle the case? And
uh,
the attorney
okay.
maybe doesn't want to settle, but the policy is getting burned up by the defense. So,
Yeah.
what's your
Most
experience there?
legal malpractice policies have what they call a hammer clause. And they could say, well, you have a right to insist on going to trial, but if you lose, you're going to have to uh, pay the costs of trial, not necessarily the indemnity, but just the costs of trial over and above what the carrier would have had to pay.
Well, was the carrier wanting to settle within the policy and the client saying, no, I want you to go to trial, or why?
Well, that I'll tell you, that rarely happens
Yeah.
nowadays. If the carrier wants to settle within the policy limits, usually, you read the riot act to the client and say, you're crazy to go to trial. Don't do it. If you lose, it could hurt your practice. So we make a confidential settlement. Everybody walks away and it's much better. But I'll be honest with you, I've really never had, um, I've never had really bad attorneys, who were maybe on it. Well, now, wait a minute, I did. I had two clients, and one was a contractor who had become a lawyer. And then he got sued by a client of his, a lawyer client of his. Um, and he, uh, I had a really good relationship with the opposing counsel. He was a former AG or U.S. attorney, I forget which. And one day we met at my office in the city, and he brought a bunch of letters that I had seen before that my client wrote to his, that they were exculpatory. But he said to me, look at these carefully. Okay. He says, no, I mean all 12 of them. Stack them up and hold them up to the light. And in every letter, the very truly yours and then his name typed and his signature were all at the same exact cant. They were fabricated letters. I took it to the carrier, they said, settle it. And we did. Not for very much, but we settled it. And he was disbarred. And he's one of two lawyers that I represented who was disbarred. He should have been disbarred. The other one was one I was defending before the state bar, and he simply refused to accept any discipline of any kind. And so the judge disbarred him. And again, I mean, there were grounds. It's been rare that I've had an attorney who doesn't take my advice, at least as a client. There are lots of other attorneys, maybe opposing counsel, who don't take my advice. But yeah, we disbar roughly 15 attorneys per month, every month.
Wow.
Uh, and then we suspend another 15 or so. And now, if I haven't told you before, I need to advise you about the snitch rule. It's new. It's 8.2, the rules of professional conduct. And it is somewhat radical. It requires any attorney, any California attorney, who sees another California attorney misbehaving in any way, acting inappropriately, harassing, whatever. They are duty bound. If they're violating the rules of professional conduct, you must report it to the state bar. And if you don't, you are subject to discipline yourself. So I had a long case that finally, after 2 or 3 appeals, 2 trials, we disposed of it. And the trial court made a notation that the attorney on the other side had fabricated documents. And I sent it to the state bar, but with the decision, thinking that's all I need to do. Well, they sent it back and they wanted, all these records and stuff. And I made my attempt to report it to them. So maybe that's what you have to do just to comply with the new rules. Okay, well, guys,
Basil, thank you so much on behalf of
Uh,
the society.
my
Let
pleasure.
me, can
Any
I
of you-
just, can I say a couple words? I want to thank Basil, but I have a suggestion for another webinar. Not as intense as this one. Many of you may know Dean Pulikitis. And he's a lawyer. I'm not sure he's a member of our society. He should be. But Dean is, of course, the son of Saki and Irene Pulikitis, and, one of the nicest couple of all time. Nick, of course, knows him very well. Dean was at Pillsbury for a while, and then he went in-house with a big leasing company, and then he switched to another big public leasing company. He's done very well professionally, but he likes climbing mountains. Dean climbed Mount Everest like 2 months ago to the top. Now I've asked him how many Greeks have made it to the top. He doesn't know, but I said, Dean, you've got to make a presentation to the to the Hellenic Law Society. I can get the rules, because you got to fill out forms, you got to get various approvals from various governments. So I'm sure we can qualify for MCLE on the processes for climbing Mount Everest, and then Dean can make a presentation and show some of the photos and talk about climbing Mount Everest to the top. I think it's a remarkable achievement. I mean,
It's incredible.
yeah, unbelievable.
Jim, come on. You can't get MCLE credit for a guy giving slides about climbing Mount
Well,
Everest.
no, but
Come on, you're going to get us all disbarred.
I would present the rules, the procedures you have to follow, and the approvals you have to get for the and if we can't get credit, we can't get credit. I think it would still be very popular with our membership to hear one of our
Maybe we
old
should
lawyers.
have a dinner presentation somewhere rather than an MCLE. So,
Whatever. Anyway,
but it's a good idea.
amazing story.
If any of you in the future have any things that come up, questions of law, whatever, you just give me a call. I'm available by email. It's basil@ptlegal.com, and by telephone, 415-472-8105 is my direct dial.
So
Stuart?
keep your cell phone at your bedside, huh?
I think Stuart logged off.
That's the truth. I actually do, but not because I get calls. That's just what I
You're
keep.
right. What's the statute? You're right.
What's that?
I get a call, say, what is the statute, Basil, on malpractice?
Yeah. Yeah.
Golly Nick to everybody.
Golly, Nick.
Thank you. Yeah, thanks.
All right.
All
Thank
right,
you, Basil.
thanks.
Thanks.
Thanks, Basil. Good job.
Hey, Hillary.